All right, welcome everybody to how to build a vendor risk management platform.
Why implement a vendor risk management program? So we all use vendors, and there's vendors of differing levels of risk, right? We have the vendor who comes in and waters the plants, and we're not generally overwhelmingly worried about them beyond the access to the office space, versus the number of vendors we use to provide services, to provide services to our clients, to provide services to us, to manage our data. And what we're mostly going to be talking about today is vendors that manage data. Everyone has some sort of system that manages their employee information, that manages their customer information. There's integrations that can provide functionality. And these vendors all receive data from you, give data to you, and there's data flowing everywhere. So one of the key issues with implementing a vendor risk management program is understanding where your data is, who has it, who has access, what kind of access, if you need it, where you can find it. And a lot of companies don't know this to the extent we wish we did. So it's really important to understand who your vendors are, what they're doing, what access they have, in order to understand what data you have and how it's being managed. Another key point, right, is data breach risk mitigation. If you know who your vendors are, you are keeping an eye on them, you've performed good due diligence, there's hopefully going to be a lower chance of experiencing a breach. And if there is a breach, knowing if you're affected, right? You don't want to find out that your systems were affected when someone else has to send a notice out. And so managing vendors can decrease data breach risks, both in understanding when something happens, what the kind of effects are, as well as managing who's responsible for what part of handling the fallout. In recent years, regulators have also been paying a lot of attention to how companies are managing their vendors. Because of data breaches, largely when one vendor has a data breach, it can lead to ongoing issues across different systems, across different companies. The SolarWinds data breach that affected the entire government was a big one. So regulators are increasingly holding companies accountable for managing vendors, for making sure that their vendors have proper protections in place and that they have proper protections in place when sharing with vendors. You can't just say, oh, this is what the vendor does. You also have to have some understanding and put controls around it on your end as well. And then, of course, privacy compliance, my favorite topic. So there are now about, depending on how you count, 20 US state privacy laws. They have limitations and restrictions on how data can be shared with service providers, processors, and they have certain contractual restrictions that are required. And so we really need to, in order to have a fulsome privacy compliance program, we also need to understand who the vendors are, your vendors are, and make sure that proper protections are in place, limitations, and contractual terms, which we'll talk about a little bit more later.
So Whitney touched on a little bit of why you need a vendor risk management program. I'm going to get into a little bit more of the how and the specifics of what you might want to take into consideration when bringing on a new vendor. And afterwards, then we'll discuss, the existing vendor management, and then we'll wrap it up with questions. So a vendor management program, what is it? It's a strategic process for selecting, managing, and evaluating suppliers that provide goods and services to an organization. So as Whitney touched on, this can really span the spectrum of anything from your coffee vendor to those that manage your customer or employee data. So this is very cross-functional, and that's why it could go so many different directions. As Whitney said, we're going to try to limit it to those that manage data, but still kind of take into consideration that it can be applicable across a number of different areas of the organization. So with a vendor risk management program, yes, you're looking to reduce risk, but there are other factors that are coming into play. There's costs, quality, performance that all have to work interdependently for you to have a successful vendor management program. So step one, it seems kind of intuitive, but it's assess your needs. What do you need and what are you looking for with your vendor? So it's a really time for you to be a little bit introspective and think about, what does your organization need? What does your department need? Whatever that might be. Can you leverage a tool that you already have? Is it something that you need to go looking for a new vendor? Maybe you have a vendor that you aren't happy with and you're looking to switch vendors. It's a time to not only look there, but then look into the marketplace and see what's out there that might be able to fit. What's going to fit your budget, what's going to be the most efficient, but also is going to fit your risk profile, which we'll touch on a little bit later.
Yeah, and I think one of the big considerations in looking for vendors for data management these days is really, what else can my vendor do? I need a vendor that does one thing. Can they offer do they also offer functionality that might be helpful for me in the future? I don't need it right now, but would I want, 6 vendors doing similar things, or can I get one vendor that's going to have offerings down the road that are going to be really helpful to me as my program grows?
Well said. Yep. So vendor selection, I'm going to draw in a little bit of my language from a time when I was in government contracts, but there can be a request for proposal, which we'll get into, or something that we term to sole source, if you have the ability to go out and pick a specific vendor and bring them on board. That's really going to be up to your organization with how they prefer you to do vendor selection. I know that when I've worked in a previous role, I had to do an RFP when I was actually looking for a privacy platform management program. I was a customer of TrustArc before coming to work for them. So surprise, surprise, I actually ended up choosing TrustArc. But that being said, I was required to look at 3 different vendors. And for me, I had to look at what was available to me. But then as we touched on in the previous slide, to see if there was anything that might be cross-functional, where we could leverage different budget from different departments. Maybe there was a higher risk profile from another department for a different tool, and like how could they work together? So I said I had to look at 3. TrustArc was one of them. They ended up winning, but I had looked up another one of like that was specific to a privacy platform. And then I actually was talking with my security guys and my GRC guys, and they were looking at a different tool that had some privacy program management capabilities. And I was able to include that in my RFP process to see, hey, it also looks like you're playing good with the team within an organization. Is it something that we can like stretch budget and combine things, but also fit all of our different needs? So for me, it ended up not being the case. I was able to pick TrustArc, and they worked for me. But again, this is going to be company specific, whether or not you can just go select a specific vendor, or if you have to look for competitive bids or different things. So in part of that process, we had to do our due diligence on each of the vendors. So as I said, we were looking for, and we were fresh. We didn't have a privacy compliance tool that we were using, but had there been an existing vendor, it was something that we could have taken into consideration, and that might be the case in some of your organizations. But you have to think about what information is this new vendor going to access, right? So data being of key importance. Is it sensitive data? Is it your employee data? What kind of data is it? And you have to evaluate the security and safeguarding that each of the vendors has in place. So, we're talking about the vendor management program in general. It's certainly cross-functional. It's not necessarily just the buyer of any tool. It's not necessarily, if you have a procurement legal department or your privacy legal department, your security department, there are many steps in the process. So you all have to work together in evaluating any vendor that you all might be looking at.
And, we really want to, when doing due diligence, want to kind of push past the initial layer. I feel like sometimes, a lot of times you'll get an answer and then you kind of need to make sure the kind of answers are fulsome, because for example, I was working with a client once. They were doing due diligence on a vendor. I believe they were sending discount codes out, and that involved an API connecting the vendor back to the client's systems so that they could identify who was a member of their rewards program and who wasn't. And looking at that, trying to figure out what data was actually going back and forth, and then I believe finding that a lot more data was going to the vendor than was actually required. All that you needed was someone to put the rewards program number in to make a match back to the CRM that sends it back. but they were actually sending a lot more of the customer information, or they would have been if we hadn't been doing our due diligence. And so making sure you're not only understanding what data is going back and forth, but how that can be limited where necessary. And if it can't be limited, if it needs to actually move back and forth, and if it how it can be protected, if maybe a little more makes sense. So we want to always manage what information is flowing and then make sure the security settings match that, right? If all you're sending is a rewards number or confirmation of a rewards number, the risk is a lot lower than if you're sending customers' full contact information to the vendor and the vendor is keeping that on file. And so the due diligence levels should at least match the level of what data is being shared with the vendor and how the vendor is going to be managing that data and what they're going to be doing with it. Because sometimes we just look at the high level, and that's not necessarily the same as when you poke around underneath the hood.
And I would say too, specifically with regards to this portion, it's truly a conversation between legal and security because, you all might be on the phone, maybe legal with their attorneys talking about this, but, your security team might not be on the call. So this one is an area where there really does need to be cross collaboration between the teams in order to make sure you get it right, right? That the security matches the need. Mm-hmm.
Absolutely.
So here's the fun part for us attorneys. It's contract negotiation. So once you've done kind of just, the steps to pick your vendor, it's time to put pen to paper and figure out what this agreement is going to look like. So the conversation that Whitney and I have had, and I'm an in-house attorney, and I was curious to know from Whitney's perspective, from being at a law firm, what the preference is or what people are seeing out there, because there will always be like an MSA or an SSA, however different companies want to term it. If there is data being exchanged, a DPA, there may be a security addendum depending upon the level of information that's being passed or the complexity of the relationship, and maybe a BAA if that's applicable to the relationship. But what I wanted to know, and maybe this is something you all can drop in the box too, is that whose paper? They're always back, it's a battle of forms. It's like whose paper are we going to use for this? Being on both sides of the equation, it's easier because we are a vendor and our paper is tailored specifically to the offering that we have. But then when you go out to RFP and people do RFPs, it's like, you can't participate in this RFP unless you mark up our paper. So Whitney, can you talk a little bit more about like what you see and what your preference is and how you advise clients specifically with whose paper?
So most of our clients, of course, want to use their paper, right? Not only because it's more tailored to their needs, but also because it's just easier in terms of doing a review to respond to edits. That being said, whose paper to use really does, it's very fact specific. So one of the main things is negotiating power. If you are entering into a contract with one of the big tech companies, they're probably not going to negotiate your small contract that is just covering a use of one of their basic services. Versus if you are entering into a contract with a much smaller company that's, doing kind of a more niche piece. But there is, of course, the importance of the technical aspects, right? So if it is a very data specific, a very technical service, a lot of times the vendor will insist on their paper because it covers what their actual service is. And so a lot of times it depends on clients, right? I have some clients who are just like, we use our paper. And if you want us to mark up your paper, we're basically inserting our contracts in, right? And that can be for many reasons, global versus local scope. If you are just dealing with one law, one jurisdiction versus a global company that's dealing across several countries. It can also just depend on kind of who's in a good mood that day. So I think what it comes down to is you can make your paper or the vendor's paper work, but sometimes that's going to mean a lot of edits. And so if you have the negotiating power, I generally find that, especially with like a DPA, there are the basics. There are the requirements under the laws that apply based on the data that's being transferred. So we all want to make sure, that if it's a service provider or processor, we have the requirements under CCPA, if applicable, the other state laws, GDPR. But then beyond that, there's the key things that you want to negotiate and the key things that are going to be really hard to negotiate. And so there are certain pieces where I might take a softer approach. For example, a lot of big tech vendors will have standard processes for referring to data breach, for referring to for noticing on data breach, for liability. And so pushing back on those can definitely be aligning with the realities of the situation versus the desires, right? While it's very hard. Most companies do not have an in-depth contract management system. You should get one. It'd be great, but that's not necessarily it. So if you have one contract that has completely different terms in terms of a notice requirement or adding sub-processors is a big one, then that can be really difficult. So we definitely if you're the customer, sometimes that can be a little more flexible so that it can align. I will say one interesting thing I've run into is where you have a contract that they don't want to include, the other side doesn't want to include details. I think it's very important to manage expectations and include details. And so if it is that, you notify sub-processors with 15 days notice, that's fine, even if the other side wants it within 10 days, but make sure it's in there so that expectations are managed. I find, especially with DPAs, there's a lot of, oh, but it'll be fine. This is what our process is. And you went, well, put the process in the contract. So I think what happens a lot is whether it's your paper or vendor's paper, there's going to be a lot of negotiation or no negotiation. I do a lot of red flag reviews, right? This is we're using Microsoft for a CRM. What are the red flags? What can we not say yes to versus, oh, let's play with these terms. Let's a few days here, a language shift here. So I think it like everything we're talking about, it's really going to depend. But I think that what it comes down to is kind of understanding what is important for your business and making sure that that's covered. So one of the things we do a lot of, in addition to having just the agreement itself, is providing guidance on where you can negotiate, where the give and take is, right? Your agreement might say a certain term and you have a little wiggle room there, or it's a nice to have, it's not a need to have, versus there's certain restrictions that need to be in place because there's a service provider under the CCPA. You can't change some of those requirements. So understanding kind of what contractual terms you need to have both legally and from a business perspective. I have a client that doesn't let their data leave the country. They do not let it be they said it can't be transferred outside the US unless it's specifically negotiated. So that's difficult for a lot of companies. But usually if you have, you can either agree, okay, you have a subsidiary in India, it can be transferred there, or you can provide access restrictions, but it needs to be stored in the United States. So it really comes down to the specific legal requirements being covered, which they are not always, and then what's important from a business perspective from your side.
Well, speaking of details, we actually do have a few questions, and the first one I think aligns very well with our next slide. But Whitney, do you include a right to audit clause in the agreement and contract?
I generally, for a data processing agreement, for most agreements, I will include a right to audit clause. Um, I will generally include that both where it's permitted or required under law, which it is in a lot of cases, but which is often limited to once a year. I don't necessarily limit it to once a year if I'm not representing, if I'm representing the customer, because I think that you should also add, um, right to audit in certain circumstances where something, if there's a data breach, if there's a piece. A lot of times we'll include additional, right? There's the right to audit as we traditionally think about it, where you go in and you have your people and you're looking at the computers. That's not really what a right to audit what an audit looks like as much in this day and age, right? Usually you can get copies of the internal audit. That can be okay depending on the vendor. Especially if their internal audit is done by an external provider, you can get certain reports rather than actually going in and talking to people. And so those are sometimes we allow them to be supplemental. They're either supplemental to, or they can be in place of. It is often a right to audit. It's not an express mandate to audit because a lot of companies don't audit. And if you have that audit clause, then that is, and you're not using it, that can also be an issue if something happens. So I think when you're doing an audit clause, you want to be realistic about what, as we said, look back at what the data is flowing. How important is that audit clause? Are they getting a lot of data? Are they getting minimal data? The coffee supplier who mails coffee to you once a month, I'm not sure we need to have a huge fight about an audit clause. But then you also want to make sure that if you have your audit clause, you're exercising your rights, right? You at least want to be getting those reports. You want someone to be looking at those, right? What are you doing with your audit rights? Have you set up a process where someone is reviewing those annual reports and making sure that you're actually understanding that? Or do you just have that right and it's kind of on its own?
Yeah, no, I think that's really insightful. I would say, from the opposite perspective, as like, being a vendor, um, I can see the customer's perspective, but with having every customer get, multiple audit rights throughout the year, it would just be operationally overly burdensome for any vendor. I think
Mhm,
also keep in mind the size of the vendor that you're working with and what the sophistication might be, because there might be just a few people, working necessarily in their security department, or whoever you might be auditing, where it would come to a screeching halt if all they were doing was handling audits all day from
mhm,
customers. So just I can only speak to, my experience within different organizations, but we always offer our compliance reports or our SOC 2, whatever that might
mhm.
be. And that if a question cannot be answered through that, then we'll have a discussion and then the right to audit limited to a year. So from the opposite side of the
Yeah.
spectrum, it might not just be that, we're trying to be difficult,
Mhm,
but it like, in terms of operations of maybe smaller businesses or,
mhm.
different size organizations, it just might it be, it'd be challenging to do. So I agree with Whitney. Definitely include a right to audit clause within a contract, but just know it might be limited to some parameters might be around it. So it's not just a free for all to stop by on a Tuesday, knock on the door, and say, "Hey, I'm coming to audit you." Yeah, yeah. I don't think that's what's being
Mhm.
contemplated here, but y'all get the idea.
Well, and
Um, Go
from
ahead. Go
sorry,
ahead.
just to push this a little further
Sure.
from the vendor side, because we do represent vendors as well,
Hmm.
is yeah, in sometimes when you're drafting these contracts, you give a little to improve the negotiation, right? So you say, okay, you have the right to audit our NIST reports annually, and then if upon request. And so
Hmm.
then
Hmm.
if it's requested, you'll share your NIST report, and that can fulfill the right to audit. So when we're contracting, um, there's the standard terms that people are looking for. And so if you're contracting as a vendor, it can be really helpful to um, cover those, right? You don't want to leave
Hmm.
out the
Hmm.
right to audit because it will be inserted.
Yeah,
Um,
yeah, yeah.
but you can define what the right to audit means. And that
Hmm.
applies to kind of all of the terms, is putting in terms that are more favorable to yourself. I will say, like, as someone who's reviewing, depending on the level, depending on all the factors, sometimes I look and I say, look, I tell my client, this isn't my favorite, but I don't have a problem with it. It's legally
Yeah,
sound. Are you going to, is this worth negotiating for you? Do you want something else, or will we just accept that? So that also goes back to why you went your own paper, because you can pre-negotiate your terms, and it honestly, sometimes it's just depending on what they want, the timeline, how it's going, what the other issues are, you might get, some of those a little more easily.
got it. I just realized that different slides. So would you mind hitting next slide, Whitney,
Oh,
whenever
yeah.
you have a moment? Yep.
Uh, there we go.
There we go. Because
Oh,
I
yeah.
think that the audit the audit clause, it hits right into
Hmm.
this box. It's and I think you just touched on it really well. It's like regular like an audit shouldn't just pop up out of nowhere if right you leave someone alone. I think a lot
Hmm.
of this can any fears can be assuaged by regular communication between a vendor and a buyer, right? So I think rather than waiting for that annual report to come up, if you have a question or you have a concern, I would say try to keep communication lines open because it might prevent the need from spending a lot of time and resources on both sides to do something when if you are constantly like talking about what you are requiring that might be able to be bypassed but yeah, so annual assessment, regular communication, and risk-based management. Again, I think that's just what we've talked about throughout this whole thing. But the types of data that are being processed, and that might change. As a relationship evolves, that might change, or the need for certain amounts of data might change as well. So just continually keeping abreast of the type of data that's being flowed, and how the relationship might change over time. And I think that circles back to the previous slide on contract negotiation. It's like if the relationship changes, do you need to open that contract back up? Can it be handled by a brief amendment, or is it something like, hey, laws have changed so much, it'd be better just put fresh paper on this relationship to start from scratch and hopefully have something that's better tailored to the relationship as it stands today. Next slide is vendor termination. I think this is something too that should be defined in the contract, or at least that, as Whitney says, like make sure you have what you intend to do spelled out in the contract so it's not like doesn't come to the end of the relationship and then you're like, oh my gosh, what do I do? What are their obligations? What are my obligations? As I've said, I've worked for a number of different types of organizations, and with some, it's like, you're given 30 days to download your customer data. For some, there might be specific steps spelled out, like a transition period with like staff members that might help you. Putting the definition around the readability of the type of data and how it is transported over to you. There's a big whole host of things, but I think the key part is having that spelled out within the contract. There should be data retention requirements, destruction processes, whether that be just like automatic if the contract terminates or if it's by request of a customer, however that might be, and whatever works for your organization, I would just make sure you spell that out as clearly as possible.
And this is one where really you want to acknowledge the reality of the situation, right? If the standard vendor termination process is this is deleted within 60 days, um, it might not be worth, if you're the vendor, you want to cover that and put that in so that they understand what your termination process is. And if you're the business, that might not be worth negotiation. 60 days would be a generally reasonable time, right? It was like we deleted in 2 years. Sure, that might be another issue. But really making sure that that's going to represent the reality, and especially if systems are automated, making sure that that's covered, because you don't want vendors to keep your data forever. That's a data breach risk. But you also can acknowledge the reality of having numerous clients and not remembering when something terminates, which is, when people are paying a little less attention, that there might be different, you might have a unique termination provision.
Mm-hmm. So that kind of wraps up our discussion on new vendors, but I think we're
Mhm.
going to touch quickly on existing vendors and then we can get to y'all's questions.
Yeah. And so, what we're really focusing on is building a good vendor risk management program. But we also have existing vendors, right? This is an ongoing an ongoing challenge. And so one of the questions I get a lot is kind of, what do we do with our existing vendors? And this comes to me a lot in the form of, there are new privacy law requirements. We need to update our contracts. We have 500 vendors. Do we need to update all of them before this new law comes into effect? How can we manage that risk? And so a key underlying piece is, of course, understanding who your vendor engagements are. Literally, what is your list of vendors? What services do they provide? What kind of information are they processing? And how are they getting that information? Do you send an email once a month with some information in it? Or do they have an API that's pushing information to them every day? And so using that, you can understand what the different risks are for different types of vendors. This can also go into ongoing assessment, right? You have your higher risk vendors who should be assessed on a more regular basis than your lower risk vendors. And so you want to, when you're creating a program, not only do this, get your controls in place when you bring in new vendors, but you also want to figure out who you also want to incorporate your existing vendors. And so by doing that, it's helpful to look at the different engagements and also see if you're using everyone. We have a lot of I have a lot of clients who have websites, and on those websites, they use vendors that provide cookies on the websites. And sometimes those are really outdated. They're not using them anymore. They're not looking at the data. It was put on for one campaign and pulled off. And there's just a cookie lingering on their website that hasn't been removed because the person who originally put it on has left and there's been, turnover. And so making sure that you're actually using all of your existing vendors. And if not, if there's anything you need to do in the termination process to make sure that they're not still collecting data from you. And so, and then of course you want to review your contracts and update it as needed. A lot of times we have vendor engagements that are a decade old. And so what that might mean is that you've been amending the same agreement for a decade. What that might mean is that you have an agreement with an online provider and they've been updating their contracts with you, but you haven't been reviewing them, right? Someone on the IT team gets an annual notice that Salesforce has updated their agreement. I'm not picking on Salesforce. That's an old example from when I was in-house. I got that email. But it's not getting to the lawyers to actually review and make sure that there's not some new term that is important to negotiate. So and then of course, updating to comply with new laws, to comply with new considerations. We'll talk a little bit about kind of AI terms, and AI is the hot buzzword right now. AI has existed for years. We're using AI in a ton of our terms. The email suggestions on what to respond to have been around for years. It's being used in new and interesting ways. And so people are very interested in it now, and we're figuring out ways that we want to contract around it. And so making sure that, so when we are managing our existing vendors, it's definitely it's a fact-based process, like everything is. So you want to look at your higher risk vendors. You want to look at people who have financial information, employee information, benefits, other sensitive personal information, who have just large quantities of data, versus vendors that might have extremely limited information. They, offer a tool that 5 people use, and they have those people's work email, and that's really it. The tool doesn't actually process personal data. So, and then you want to make sure, you want to prioritize those higher risk vendors and look at what they're doing and use that information to figure out, do you need to update your existing contracts? Are there new things you care about? Because also internally, you want to make sure that your vendor contracts, your audit your processes are in place to keep an eye on your existing vendors as well, not just new ones. Because a lot of times these relationships, if they're going well, they last for a really long time. And we like that.
Mm-hmm.
All right.
With that, I think we should move to questions. We have quite a few of them, which is exciting. Um, Let me start. So, are you redlining the right to use your data to train models?
Yes.
Yes.
um, this is so, from an AI perspective, we're looking at um, how our customers' data can be used. We're looking at how or how my clients are using their customers' data, and we're trying to find that balance between allowing data use to improve tools and also not causing issues with the client's data and with personal information, right? So I think
Mm-hmm, mm-hmm,
one of the big considerations is how is personal information being used. Once information goes into model training, it can't really come out. So even where we're looking at kind of future ways that might be used, future products that might be developed, um, we're putting in language that tries to take it into account what might happen in the future and
mm-hmm,
tries to make sure that the parties are both protected and that a lot of these tools can't get better if you don't use the data to train them. So we're also looking at kind of what data is allowed to be used versus what data cannot be used. And I will say, personal information is a big one, and but it's very, very fact specific. But I'm rarely taking things at face value there. But a lot of these standard contracts right now don't have a lot about this in it yet. So
mm-hmm.
we're also adding limitations where the contracts are silent.
Got it. Okay. Next one, have you seen a customer or client ever build VRMP in Microsoft 365, SharePoint, or similar software? I can say in any of the organizations that I've worked for, I have not seen that. We have used different vendors for that, but Whitney, how about you?
I wouldn't say that would, I don't know of a tool that they have that's particularly suited for that, but
Mm-hmm.
I have seen clients use every software for every sort of
Yeah,
purpose.
yeah.
The amount of people who are building things in Excel that don't necessarily need to be in Excel are a lot. But I would say there's probably more tailored solutions than that, though I think I probably have less experience than Kathleen on the specific
Yeah.
software options. I more get brought in on the underlying question.
I will just speak to previous employers. I
Mhm.
know that one that was very helpful, and this is not a paid endorsement, but Coupa has been very helpful to a large organization that I've worked for. But yeah, I think that I'm not sure what's driving this question, if maybe you're trying to leverage some Microsoft 365 capabilities that you all might already have, but there are more tailored software solutions out there. I'm just not sure if maybe it's a budget thing or whatever that might be. But no, I personally have never seen it. Next question. Do you try to avoid situations where vendors want to be joint controllers?
Yes. Um, it's not, I don't generally try to, okay. Generally speaking, both from a vendor and customer side, I feel like the go-to is a controller processor relationship because it manages risk in a way that both parties generally where the reality of the situation states that both parties are controllers. So, sorry, quick background for those who may not be as familiar. Controllers are those who decide what to do with the data. Processors are those who use the data as uh, told to by the controller. And so a joint controller is when actually both parties make decisions about the data, but the same data set. And so that's just incredibly difficult from a practical perspective. So if you have a controller to controller relationship where I'm transferring data to you and you can use it for your own purposes, you can include limitations in the contract that says, okay, even though you're a controller, you're still only allowed to use the data for these purposes, right? Like
Mm-hmm.
there's not a, you're not prohibited from doing that. So I find that can be a more practical way to carry out a contract rather than joint controllers. Joint controllers also just don't exist in reality as much as sometimes uh, they might be presented. There's because it has to be both parties making decisions about the same set of data. And so usually it's not the same set of data. It's I'm transferring data to you, you're using it for your purposes. You might be transferring other data back to me once you process it, but it's not okay, we both have this platform that we can both access and we're only using it for for very specific reasons that we're making decisions about together.
Mm-hmm.
And so while that does exist, of course, that's why joint controllers exist. Generally speaking, if it's a joint controller situation, I'll look at the facts and say, okay, is this actually a joint controller situation? Does it make sense to be just a controller to controller relationship and put limitations on how the data could be processed?
I guess question for me is that, within certain engagements, do you see like different uses within the same agreement? So say something like usage data
Mhm.
or, that data which might be held in the platform or a SaaS solution.
Mhm.
What's your advice on those situations then for a similar question?
So you can do a controller to controller slash controller to processor agreement where you say, okay, we have, you know, as as your vendor, we're going to be processing this data on your behalf, and
Mm-hmm.
we are only going to do this on your behalf, and we don't have to, and we'll do whatever you say. But then this other data, we're going to process on our own behalf,
Mm-hmm.
and for those kinds of data, we're going to have a controller controller relationship. I think one example that I really like to use, once again, not because I just think it's a good example, is ADP. A lot of us are familiar with
Mm-hmm.
ADP. They give us our paychecks. We really like that. Once, so in addition to your employer having a relationship with ADP, they are their vendor. You actually also have a relationship with ADP. And
Mm-hmm.
so there's certain data that they might be getting from your employer. And I have not looked at an ADP contract, to be clear. This is just about the relationship. Um, they might get certain information from your employer that they can keep, right? Your W-2. I can go back to previous employers and find my W-2, and I would venture to guess that my employer can't delete my W-2 from ADP, right? That is
Mm-hmm.
it in that relationship. Once again, I haven't actually looked at the contract, but because there's those multi-levels of relationships, I would imagine that their data processing agreements are covering all of those because yeah, I can go back 2 jobs ago and still find my own work.
Yep. Okay. So, next question. For annual audits, if you have limited resources, what is the best way to complete a vendor audit? Is it a questionnaire? Who is responsible for completing such audits, IT or legal?
So
I'll take a stab at this one to
yeah,
begin with,
okay, great.
too. I would say both. I would say this is again part of that cross collaboration that we discussed earlier is that, you know, not everyone has the answers for everything. And I think with questionnaires being tailored to specific agreements and then, different customers might ask questions in different ways. What I've seen that's worked well in other organizations is that, legal and IT will get together and put together a playbook with basic answers for some of the most common questions that they see most often. I think then legal typically will try, whether that be procurement legal or that may be privacy legal or whatever, it's going to vary depending upon your organization and the size of your legal team. But fill in those that you can and then escalate the higher level and more specific questions to IT, security, whoever that might be that has the answers. But not it's not a one-man team here. I think that you're going to find your answers throughout the organization. Questionnaires, I would also say limit to like one per year because they are time consuming and can be a drain on resources. So we all want to give you all answers, but they do take time as well. So that's, I've seen similar language. If it's going to be a questionnaire that's happened, then no more than once per year.
Yeah, no, I think that makes sense. And this is both from right a vendor side or a customer side because it's a lot, it's difficult for everybody, right? It takes time, it takes expertise you might not have. Um, I would say, yeah, if you're going to be if you're going to provide a questionnaire, um, as a customer, take into account who you're providing it to, who your vendor is. A lot of times, if you're a vendor, having a preset response can be very helpful, can reduce the burden on your teams, and can make sure from an IT side everything's accurate, and from a legal side everything is good to go out the door. And so um, it's but this is also where you want to, in your underlying contract, set expectations, right? If
Mhm.
you are a small vendor and you have a big company that says we have a questionnaire we provide annually, you might want to negotiate to provide results of a check you already do, right? At this
Mhm.
point, if you should be doing annual checks on your cybersecurity in general. But and then hopefully if there's any kind of additional questions that they need the answer to, this should also be an iterative process, right? So you suddenly realize clients keep asking about a certain topic, maybe prepare some responses for that.
Mhm. Yeah, I agree. What contractual red flags should you look for in a contract tied to AI?
So that this is I'm gonna politician this one a little bit. I'm based in DC. It really depends on who you are and what you're trying to get, right? I think
Mhm.
when you're doing a contract tied to AI, what you need to understand is, first of all, what the AI is doing. I know that seems straightforward, but not everybody does. What the AI
Mhm.
is doing and what functionality is in the immediate roadmap that might affect your contract, right? So usually there's kind of a logical nexus with what some of the next steps are, but you might not have the expertise in that. It's not your area. So you want to understand what the AI is doing, and then you want to understand how your data, if you're the customer, will be used related to the AI. So
Mhm.
I will say I have a client. They have a very cool AI solution that uses a lot of data. And when I was learning about what it was, when I first learned about it, I was a little scared because it used medical data. But then when I learned what their actual processes were, and I learned how they use that data and what their anonymization procedures were and how that was integrated with their clients, that it was actually just a small subset of data, suddenly it became much, much less heartburn inducing. So understanding what their AI does, how they will use your data
Mhm.
related to that AI, then you can put in logical limitations on what they can do. Because contracts from a customer side are going to be broadly prohibitive, and from a vendor side are going to be broadly permissive. But the reality of the situation, and this is evidently my go-to this webinar, which is we have you looking at the reality of this situation makes negotiating these easier, and taking that time to figure out what's actually being used so that you can put in logical um, limitations or permissions is going to be really helpful in determining what you need to put in there. I will throw out, just because I think it's one of my favorite stories. I was once on a client call. There were, I think, about 6 lawyers on this call from both sides. We were negotiating the DPA for a contract. There were 2 or 3 business people. And after 30 minutes, we realized absolutely no data was being exchanged between the two entities. It was an on-site solution that didn't have any data going back except for actually like about the functionality of the machine itself. and none of us needed to be there. Um, and in that case, it did take all six of us, but it was, once we understood what was happening, it made the negotiation really easy because we didn't need a DPA. And then we included some language in the main agreement that said, no data will be transferred. And if it is, we need a DPA. So
Yeah.
understand the facts.
I will also throw something in there that I think that's a really, really good point is understand the actuality of the situation, especially when everyone is dealing with templated contracts and where there may be a disconnect between, say, a legal department that might be specific to procurement and looking for certain things, and maybe a privacy attorney that actually understands about what data is being, like contemplated here, being transferred. Because a lot of times templates don't match and procurement attorneys might not know that. They might not understand the engagement that's being really, it's through no fault of anybody's own. It's like, but if you're looking at something in a silo, sometimes it can get lost. Because similarly to you, I've been given like on-prem contracts with all of this information about like on-site visits and all this stuff. And I'm just like, I recently received a 147 page one. And I was like, 70 pages of this are just not applicable. And I redlined out and was dealing with a procurement attorney on the other side, and they're like, "Well, why?" And I'm like, "Do you even know what's being bought here?" So I think understanding the actuality of the situation and also having that internal communication, not just with a vendor, is so important to make sure people understand what's really going on. So I've seen it both ways. Um, all right, next question, because I think we got 5 minutes. So I'm trying to get through as many of these as we can, but I know I can make myself available by email afterwards. And Whitney, I'm sure you might as well, but I don't want to speak for you. But what about pen test clauses in contracts? Also, for vendor breach or third-party breach from vendor, how quickly is the standard to be notified?
I will say pen tests, you're having standard security requirements that you think are important both as a vendor and both as a customer are helpful. Pen tests are a really common cybersecurity protection right now, so it's not uncommon to have them if you're not doing them as the vendor, and so you don't want it in there. You should have an explanation of why and what other controls you have in place. And then the standard should be notified for vendor breach or third-party breach. It's 3 days. Right there, it can be changed. A lot of customers will ask for 24 hours. 72 hours is standard, usually because that's when the government wants to be notified. So because there are other notification requirements there, though if you're subject to certain laws, the notification standard is very short. It can be as little as 24 hours. So I think when you're having those breach notification conversations, once again, it's important to talk about the reality of what's being covered and whether it makes sense to have a shorter or longer one. But I think most of the contracts I see default down to 72 hours after negotiation.
And that's what I've seen for the most part as well. I'm just going to try to squeeze in as many as I can. So let's try to get to two more. Do you think it's common to give vendors an irrevocable license to the data they process on your behalf for their own statistical analysis and to improve their services? I keep seeing this come up more and more over the last year.
I don't think it's uncommon. I don't know if I'd call it
Yeah.
common. I think that there's a lot of places include certain rights, particularly based on what you can do as a business purpose under the CCPA. But that is something that can be negotiated. And once again, you want to know what data they're using. And that can also be limited or
Yep.
permissive, but specificity could be really helpful there.
Yeah, I definitely agree with that. What's the best way to manage contracts with professional services companies, e.g., Big Four companies, who tend to farm out companies for various types of SOWs that are so different? Often they don't always want to agree to certain privacy terms at an SOW level.
This is where negotiating power comes into play, right? The Big Four are going to have a lot of negotiating power. This is managing requirements under laws and pushing what those are, including anyone that they have to send your data to has to have a similar similar requirements as the contract that they enter into with you is a helpful way. But this
Mm-hmm.
is one where this is going to depend very highly on negotiating power, and you need to determine kind of what's important for you. And then you can limit what kind of data you share based on that as well. But there's also a lot of kind of regulation there. So relying on regulatory requirements can help.
Got it.
Thanks so much. Sorry we didn't get all of your questions. We tried to leave time, but I can be very long-winded.
It's, all right. Thank you all so much for attending.